You see, one of the strange things about this judgment, it was arrived at in a matter of a couple of weeks. Normally these judgments take months to be teased out by the judges, because there's a lot of writing. Like this one is 76 pages, and that's a lot of writing, a lot of, when you have 7 judges, a lot of thinking, a lot of talking, a lot of comparisons. So that tells me that, and this is supported by a lot of the evidence, just looking at the documents, that the court has co-opted the submissions of the state into its judgment. It's basically transcribed the state's arguments. And this is a really good example. And the court at this point says that reference is made in Article 42A to the requirement to take into consideration the voice of the child. It will therefore, it says, be readily apparent from the provisions of Article 42A, and it goes through the various sections of that, that the reference to a child or children in those sub-articles can only be a reference to a child or children born alive. But you see, that's actually not right. Because the provision in Article 42A in respect of the voice of the child has always been seen to refer only to older children. You know, this is something that's been in part, even long before this, the practice in children's proceedings, in family law proceedings, was that it was possible for children of a particular age, usually children who have gone into double digits or into adolescence, 10, 11, 12. But under that, it would be unusual for a 9-year-old to be allowed to speak to a court or to a judge about his or her wishes in any particular proceedings. So therefore, the idea that this Article 42A does not or could not include the unborn for that reason is preposterous and completely ignorant on behalf of the judges who have made this pronouncement, because all the time children who are being born are excluded from having a voice of their own by virtue of being too young. So a 2-year-old is incapable of speaking to a judge or to a court about his or her wishes, and that's accepted as part of the custom and practice in court proceedings. So this is deeply alarming. The Supreme Court have clearly taken an argument put to them by the state, a disingenuous, dishonest argument, because the state knows this, and without thinking it through and without checking it out, have written it down in a judgment of the Irish Supreme Court, where it becomes the law of the land. That is deeply, deeply alarming for Irish citizens.